feel safe with the monitor being removed. And the reason why, you can unfold your hands.
Every time I've been calling lately, it's been about.
Okay, here's the thing. You're talking very fast. The court reporter, you're making her job more difficult than it needs to be. When you're a judge, you're not supposed to express yourself on the record, because if you do, and you were a judge, so you know, they say as little as possible. But
She laughed in my face after she got done beating me and said, "It's gonna be real funny when you go back to jail after I call the cops." And she laughs and goes to her room, and that's when
I'm a full-time dad. I don't work all the time, and the reason why I'm in trouble right now is because can I say that?
Tell me, what were you thinking? Because I read the report. Not only were you intoxicated with a 2-year-old in the car, but the 2-year-old was not even in a proper carrier.
Judge, she is a little nervous, so just a little patient.
Yeah, don't be nervous. Just tell me the truth. Why are you driving without a license? How old are you?
JudgeBoyd, I'm 53.
Why are you throwing rocks at somebody's vehicle like Ernest T. Bass? Why are you doing that?
Welcome to the reality of the courtroom. The judge is immediately cutting through the noise and demanding clarity, not just for the defendant, but for the court reporter, a crucial but often forgotten player. This initial monologue is a strong hook, showing the judge's no-nonsense, highly communicative style. We know we're in a high-stakes setting dealing with serious, repeated offenses, setting the stage for the rest of the hearing.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
I believe we got it last time, yes, ma'am.
Well, no, my question is, did you review it with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
All right. Are you the same Moses Ross who was placed on deferred adjudication in 2023, yes, CR 3543 for the offense of assault, bodily injury, married, family on August 24th, 2023 for a period of 1 year? Is that you?
Yes, ma'am.
All right. State.
Your Honor. On or about the 27th day of September 2023, in Bexar County, Texas, the defendant, Moses Ross, did then and there fail to register for and attend battering intervention and prevention program with an approved agency in violation of condition number 18.
How do you plead to that? True or not true?
True.
Pleading true to violation of condition number 18, the court could find it true, grant the motion, find you guilty, sentence you to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation 18?
Yes, ma'am.
Court will find violation of 18 true. Is there a proposed agreement?
Yes, Your Honor. The proposal, when in conferring with counsel, Your Honor, would be to revoke and adjudicate via a judgment satisfied in an affirmative finding of family violence, Your Honor.
And how much time?
Legal breakdown. The defendant, Moses Ross, is on deferred adjudication for assault family violence, AFV. He just pled true to violating a condition, failing to register for the BIP, Batterer Intervention Program. When you violate deferred adjudication, the judge can revoke it, find you guilty of the original charge, and send you to jail or prison. The state's proposed deal, judgment satisfied, suggests they want to close the case immediately, essentially giving him credit for time served. The judge, however, is clearly not satisfied with this easy out.
How are you all requesting?
It would be, there's 13 days served, Your Honor. The underlying probation is for a Class A misdemeanor. Mm-hmm. And so the state confirmed that, yeah, there's 13 days credit. And that was the proposed agreement, if you will, between state and defense.
Correct, Judge. All right, so here's my question. What has he done on probation? It appears that the main thing that needs to be done when you're on for assault is the BIPP course. So has that been completed?
No, ma'am, but I can tell you what happened.
Sure, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Moses Ross. When I got put on probation, I went back to jail, and that was the time that I was supposed to sign up for my bibs. During the time
Wait a minute, that was supposed to be the time you did.
That was the time that I was supposed to sign up for my bibs course,
Mm-hmm.
but I was in jail, And then when I got back out of jail, I got put on a monitor, on the ankle monitor. She's very difficult. I made an appointment to go. She approved it. I went, and they said to Bibbs. They said that I needed my court paperwork and $25, which I was unaware of. So I didn't get to sign up that day. Before, you know how I told you last time I said, well, can I fix what I've done wrong? And you said, you do whatever you want.
Yes.
When I made an appointment last week, and I sent her all the proof and the appointment stuff, and she says, well, you're not telling me soon enough. So what don't you understand about you having to tell me if I could go or not? And bid classes pushed back a week or 2 weeks every time. So they had someone that dropped out. I got that appointment. I went to my PO, my probation officer, excuse me, and I got my paperwork for court, and I had the $25. I make 25 each time. I made my appointment. I sent her the information, and she didn't let me go to the course. I've tried several times to go to the course, and there's nothing that I'm not like avoiding the course because of anything. It's just the monitor really, it messes with my school. I'm still in school. I quit my job because my manager didn't want to continue to print out my schedule every week for my officer. The officer.
Okay, well, what I can.
Moses is laying out a classic defense. The system is fighting me. He blames the ankle monitor, his PO, and unforeseen cause for his failure to complete the essential BIP course. However, the judge quickly dismisses a judgment-satisfied deal, emphasizing that the BIP course is the most important condition for an AFV case. This is a critical turning point where the judge refuses the agreement and decides to take control of the case, leading to the highly specific discussion about the GPS monitor.
I tell you is I'm not the person who placed you on probation. Somebody else did. I don't think that revoking him, he's only been on probation since August. So that's September, October, November, 3 months probation on an assault case. I'm not going to give him a judgment satisfied for that. I want him to complete the BIP course. After he completes the BIP course, if people want to come back to me and see if I would consider early termination, then of course I would consider that. Okay. But for me, the main thing on an assault family violence case is you complete the BIP course. And there are consequences to a revocation and a guilty plea on an entering of guilt in the judgment from the court on these assault cases.
I agree with everything you're saying. My question is this: would you consider? So he's a professional barber. Mm-hmm. Would you consider, so that he can do his bit, get a job, get employed, pay probation? Would you consider removing his monitor so that he can resume working, going to school, and doing that?
I would consider tracking, but I will not consider removing the monitor unless somebody tells me the complainant is aware that the monitor is being removed and the complainant feels safe with the monitor being removed. And the reason why, you can unfold your hands. All right. People always.
This is a judge drawing a bright, emotional line in the sand. The judge clearly states her top priority: the complainant's safety. The GPS monitor isn't just punishment. It's a security measure, especially with a no-contact order in place. The judge is prioritizing the victim's peace of mind over the defendant's inconvenience, the job/barbering argument. This is a vital legal principle in family violence cases. Safety first. Her comment about unfolding his hands is a classic, witty piece of judicial theater.
Would tell me in class that when you fold your hands, that means that you're upset, or it means that you're closing yourself to information that's being delivered.
That's funny.
And sometimes I do this and I'm like, I'm not closed off. But my professor would always say, that means you're closed off. So you're supposed to be open to receiving. Yes. So people will always say that when you're a judge, you're not supposed to express yourself on the record, because if you do, and you were a judge, so you know, they say as little as possible. But I'm a firm believer that communication is key. And I don't like for people to think that I'm just doing something because I can. So the reason why I'm looking at tracking is because one, I don't have any information from the complainant saying that they're not in fear. I don't have any information from the complainant saying that the complainant is aware of what's going on here today. And even if I were to give you a judgment satisfied, that's another concern, because part of my duties as a judge, when it's in my purview, even that's okay. Even when I'm setting bond conditions, I got to make sure that the public is protected, right? So, and let me get some update from probation. All right. And they say, she's telling me that there's an issue, the monitor, it's pretrial service issue. Norma, can you get the pretrial services officer to zoom in?
Do you need your pretrial service?
Is the issue?
No, we're trying to find out what the issue is. See, we're trying to get everybody on the same page to communicate. So who is the person you report to with the monitor? What's her name?
Parvo, Miss Parvo, CHA, Shay, Parvo. I got it on my emails.
Yes. If you will give that to the court coordinator, and we'll get them to zoom in, and that way everybody will be on the same page.
Even
just
tracking would be amazing too.
No. Just give the information to the court coordinator.
He can call the person.
And so if you all will just wait,
Okay.
and we will take that up, and that way communication is key. Ask that the pretrial service.
Pure logistical chaos and a dramatic call-in. This segment highlights the real difficulty in managing complex criminal cases. The judge has to pause a hearing and get a pretrial services officer to zoom in, then switch to a cell phone just to verify the defendant's compliance status with the monitor. The officer's report is a key reveal. There's been no violations. This is great news for Moses. It proves he's compliant with the monitor, if not the BIP course, and directly influences a judge's decision to order GPS tracking instead of full revocation.
Services officer zoom in. She's unable to zoom in. Is there any objection to her appearing by cell phone?
No objection from the state, Your Honor.
Not from the defense.
All right. Could you state your name for the record, please? All right. Could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand. We are here on Moses Ross. Were you able to pull up his file? All right. He's saying that there's an issue with the GPS. Is there any type of issue?
Yeah, I know that most conditions are partial GPS with a no contact order. Let me double check if there's been any issues within, as well as including violations. There has been no violations. There has been an update letter that was submitted on October 11th of this year. No violations so far. I don't see anything in regards to issues with this defendant.
All right. So with regards to him, would you have an issue with him being on tracking?
No, Judge. I don't see a reason. He's been in compliance. I see no violations have been submitted. I don't see anything that's been entered in informing me that it would go against him being on tracking. No, Judge.
All right. Any other questions?
I do have questions. What are the exact rules for tracking? And
tracking, you just don't have contact with the complainant.
So there's no,
and they know where you are at all times.
Yeah. So just keep it charged and go about my day. Just
Yes.
don't go to her.
All right. There's no reason for you to go beyond 75 miles.
No, ma'am. No, I'm not. No,
No, he'll be within the 75-mile radius.
Thank you, Judge. That's all that we have for tracking.
Is there anything else? Any other questions?
When does it come into effect? Because
It's in effect today.
Thank you.
All right. Is there anything else?
Nothing from the state, Your Honor.
All right. Pre-trial, is there anything else that you need from him?
No, Judge.
There's no curfew, nothing like that. I don't want to get in trouble. I hate getting in trouble. I don't get in trouble.
There's an order to things. Any other questions from the pretrial service officer?
No.
No, Judge.
No, Your Honor.
All right. Thank you so much for zooming in or trying to zoom in. And thank you so much for being by phone. No, I appreciate it. Thank you so much.
Thank you.
All right, you too. Bye-bye. All right, so this is what the court is gonna do. Court is gonna deny the motion, alter and amend conditions to include GPS tracking. And when can he start the BIPP course? Do we know?
I have to do it. Right. Right when I get out of here, I call them. I make an appointment with them. If they have any fallouts today, I could get it today. But usually they're about 4 days out, so it's not that far. So by next week, hopefully. I don't want to put it too close, but it's a holiday. Every time I've been calling lately, it's been about.
Okay, here's the thing. You're talking very fast. The court reporter, you're making her job more difficult than it needs to be.
Yeah.
All right. So probation, he needs to be enrolled.
Generally, Your Honor, he'd say within 10 days of whatever ruling of the court that the enrollment happens. So can we just give him 10 days
Yes.
threshold? And I just want to confirm GPS, alter and amend those conditions are bond conditions, not conditions of.
Yes. All right. So you're to enroll in BIP no later than December 18th.
Yes.
The final ruling. The judge denies a motion to revoke but amends the conditions, switching him to GPS tracking to solve the employment issue and setting a firm deadline for the crucial BIP course, December 18th. This decision shows the judge's focus on rehabilitation, get to work, get in BIP, alongside punishment/safety, keep the monitor for now. Moses is getting a second, heavily monitored chance. Do you think the defendant will successfully complete the BIP course by the judge's new deadline? Let me know in the comments.
That's giving you more than 10 days. Do you understand?
Yes, ma'am.
All right. If there's nothing else. All right. You're welcome.
Thank you, Your Honor.
Thank you. Have a good day.
Defense, have you received all the discovery? Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication? Did you understand it? Did you sign it?
Did we send it? Yes, ma'am.
All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Your Honor, the state is proceeding on the lesser included offense of assault, bodily injury, family violence.
Any objection?
No, Your Honor.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, is this an application for deferred adjudication or no?
Judge, we have filled out the form for deferred and for probation.
But is your agreement for deferred adjudication?
Our agreement is only for straight probation, 1/2.
So are you all opposed? Because he's saying he filled out an application for deferred.
It was not a part of our agreement.
Do y'all need to discuss that?
Well, the way I understand it is he is in favor of probation,
Yes.
right? The state is in favor of probation. Which is to say that he's not in favor, or the state's not in favor of deferred, but that doesn't preclude me from requesting deferred.
No, if they are opposed to your application for deferred adjudication, then they need to check the box that they're opposed to application. Right now, I don't have.
The agreement was for no application for deferred. It was an agreement for 1/2 straight probation. At this juncture, I'm happy to just go on the record and maybe note if that's helpful to our opposition to it, but the agreement was only for 1/2 straight, given that it was a reduction to an ABI misdemeanor. And we don't really typically offer those as a matter of course for reductions.
Okay, well then scratch our application for deferred.
Okay.
We'll just go straight to probation.
All right. Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, family violence as a Class A misdemeanor? Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yeah.
Anything you wish to say on behalf of your client?
Yes, I do, Judge. He is gainfully employed. He's a licensed barber. He has been on ELM, Judge, since he was released from custody back in March. And he's had no violations and no problems whatsoever in informing his conduct and the requirements of bond conditions as well as court imposed conditions. So he's doing very well.
All right. Do you have any children?
I do.
What are their ages?
She's 1.5, well, like a little over 1.5. Her birthday's in September. She'll turn 2 in September.
All right. And who's her mother?
Abigail Laurel.
All right. So the court is going to sentence you to 1 year in the Bexar County Jail, suspended and probated for 2 years. There's an affirmative finding of family violence. There should be no contact with Destiny. Is there anything else you need from the court?
But she's already on one of your hit programs.
All right.
I just wanted to know if
Have you completed it?
I'm close to it. I have a class tomorrow. I just wanted to, because I'm busy and I have my daughter Sunday, Monday, Tuesday, and then I drop her off Wednesday in the afternoon. So me already with that one class is stressful, and I just finished school and what have you. So I already missed my 3 classes for bibs when I went back to school and graduated for the barber program. So I'm already like I'm close with them. So I just want to know if there's any way that we can waive the parenting program and keep me on bibs, please.
Oh, I'm not waiving the parenting program.
No.
No. And let me just tell you why. See, sometimes people say probation is hard in this court. Deputy Laura sometimes says, what she says. And people think probation is hard. But let me explain something to you. This is why I want you to do parenting classes. You're here for a violent offense. The person who decides that she doesn't want to cooperate with the state in proceeding in this prosecution, in the police report, she says that you spit in her face. That's what she says. This is a female. Your daughter is a female. And if you really think about it, how would you feel if your daughter were with a guy and that guy spit in her face?
There's no justifications for that, but my daughter most definitely won't put her hands on someone else.
No, but here's the thing. Spitting in somebody's face, whether they put their hands on you or not, that's pretty low. And I don't think you would want somebody to spit in your daughter's face. This is what it says in here. And then it says that you got upset. You were playing video games. So that means that you have time. She said you were playing video games. You started getting upset, cursing and yelling. So she just wanted to avoid conflict. These are what y'all stipulated to. And it says that she went into her bedroom, the master bedroom, and locked the door. And then she wakes up. You mount her on the bed, start calling her the B word, choking her and slapping her. And it says that she yelled for you to get out of the apartment and to leave because she was going to call the police. And then it says that you spit in her face, cussed at her some more, then left the apartment in a black Mercedes. Those are the stipulations. So that is why I'm ordering parenting classes, because people do not understand that when you are in a toxic relationship, wherever you learned how to be in a relationship, I don't know if people learn it from their parents. Maybe that's the way they solve problems. I don't know. But the cycle needs to stop. And parenting classes will let you know how your anger or whatever you're doing really does impact your child. And the fact that you say, oh, I got to work, I got to do this, I got to do that, that's part of the impact of this. Now, as far as whether or not I will keep the stipulation for the BIP, the stipulation for the BIP course is going to stand in this case until I see what he has learned from the other BIP course. If he has learned nothing from that BIP course, and I think he hasn't learned anything, it's going to remain in this, because obviously he will not have learned anything. So we'll cross that bridge when we come to it.
When will that be?
Oh, whenever he completes it.
Okay.
I could talk, right?
Sure.
As when I just signed the paper, they just said that the evidence was like not correct or not like
Not contested.
not so
Oh, no,
there's-
here's the thing. A no contest plea, you know what that means? A no contest plea is saying, in layman's term, I'm not saying I did it. I'm not saying I didn't do it. I'm just not going to fight the charges against me. A judge can still find there's sufficient evidence to find you guilty. Usually clients plead no contest. And the reason why they plead no contest is normally because maybe there's a civil issue that they see coming up, or maybe they have a custody issue, or for DWI cases, they're being sued civilly. And then when you're sued civilly, if you enter a no contest plea on the criminal side, then they will have to prove the causation. But if you were to plead guilty, all they need to do on the civil side is take the guilty plea over there. And then in some cases, the only issue is how much money you're going to end up owing.
Is there any way I could say like my ends? But I'm not trying to argue with you like by any means. It's just something that I just feel like I would want to explain myself. If there's
Also, when we negotiated the plea bargain, Judge, it was for no vicious or injurious contact, because these folks still have contact.
Oh, here's the thing. That relationship is over. It's not working.
No.
And let me just tell you why. Number one, you're standing before me and telling me, well, she hit me first.
No, that's not what I'm trying to say. That's
Well,
what
I
I'm
mean,
saying. If I could,
she's saying that you spit in her face.
and okay,
And your response to me, and correct me if I'm wrong, and I'm gonna give you a chance to talk. But when I said, she said, you spit in her face, and I said, how would you feel if somebody were to spit in your daughter's face? And you said your daughter wouldn't be putting her hands on anybody. Isn't that what you said?
yeah,
All right. So that's telling me that you're saying that maybe you spit in her face because she put her hands on you. Either way, it's a toxic relationship and y'all shouldn't be together. Y'all don't have any children together. Do y'all have any property together?
no, I don't want to be with her. That's not what I'm trying to say.
Okay.
I don't want to be with her by any means.
Okay.
She's done enough. Trust me.
Okay.
I touched the fire one time. I get burned. I don't touch it again. I'm pretty smart when it comes to that.
Okay.
So, no, when it comes to the spitting in the face is after everything that happened, everything you said most definitely did not happen. But with the reason why I did do that is because she laughed at me because she was hitting me the whole house. I'm packing my clothes, I'm packing my barber stuff, packing the game system that I was about to play, was packing all that. So during that time, she's hitting me the whole time. I have scratches on my face, there's pictures of that. She's punching me in the back of the head. I get dizzy. She's getting stuff out of my barber stuff. She went to go throw that away or hide it. I don't know what she did with it. During all this, she knows what I'm really fighting as well. She already knows I've known her since I was 15 years old. I'm 25. She already knows everything that I was going through with my probation and my current charges or what have you. She laughed in my face after she got done beating me and said, "It's gonna be real funny when you go back to jail after I call the cops." And she laughs and goes to her room, and that's when I spit on her. Regardless, it was not right, but I did not put my hands on her one time, not choked her, nothing like that. I was getting all my belongings out of her apartment, get into my car. I didn't even have time to call the cops. So I'm super smart. I'm beyond smart, and it's kind of embarrassing to even be in this situation with the ankle monitor on my ankle. So, with me mounting her and cussing at her and choking on her, most definitely did not happen. I just and thank you for me even taking the plea that you gave me, or the opportunity you gave me for this year's probation. I appreciate it. I just felt like I needed to get that off my chest because I just feel like what's right is right, what's wrong is wrong, and I most definitely didn't do that. And I've been in your court before, and I took my charges when I needed to take my charges. So, and I most definitely didn't speak my piece on it because I know I was wrong. This one I most definitely feel way different on.
All right. So what are you saying? You want a jury trial?
No, I don't. I'm just want to get. It goes back to the parenting and like the spin in the face and that reasoning. I just wanted to explain it more.
Okay. All right. Is there anything else?
My monitor. Can I take my monitor off, please? Could I take the monitor off?
Six. All right. State why you're opposed.
You just signed up for a term of probation. I think if circumstances were different, they wouldn't have gotten the plea they got in the first place. So that's why we're opposed.
All right. So how long has he been on the monitor?
Since March.
All right. This is what the court is going to do. State, do you have contact with the complainant?
Yeah, we have their contact information, yes.
All right, so what I'm gonna do, I'm gonna keep you on the monitor until July 1st. State, that'll give you time to reach out to the complainant and let her know that he's on probation and that the court is considering removing the monitor on July 1st. All right?
Yes, Judge, yeah, I'm texting.
And let the
you right now.
complainant know he's to have no contact with her. And I would hope that she would not have contact with him. They don't have any property together. They don't have any children together. They don't have any loans together. So she should not be contacting him. All right?
I said one more thing. I've been in court since 8 this morning. I usually charge it in the mornings. I think it died. I think it died when I was here at court.
Well, in fact, I
Ow.
know it died because they've been calling my office looking for him.
All right. Well, probation will let them know it died here while we were awaiting for parties to appear.
But the monitors that's through pretrial services.
All right.
That's not a-
So I'll email pretrial services. I'll find out who his pretrial services officer is, and I'll let them know that he's still on the monitor and that it died while we were waiting for parties to appear.
And then I could go June 1st to get it to July 1st.
July 1st, you come back to this courtroom and probation is going to give me an update and let me know if everything is okay. And if everything is okay, yes.
But that's the problem with the monitor. It's being serviced and everything through pretrial services, so we won't have that information. I know you're putting on probation today, so if he's gonna be on a monitor with probation, they would have to be switched out. It's not a.
Oh, no, I wasn't going to put him on the monitor with probation. I'll just let him keep this.
Okay.
Yes. And what I'll do is if there's no objection, I'll contact his pretrial service officer and ask them if there have been any issues with his monitor.
Okay, Judge. And then at that point, I can give you an update on how it's going on probation.
Yes. And then you can give me an update with the BIPP. All right. Is there anything else he needs, probation?
No,
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because there is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
It's family violence, but MTR, but the new number ones are criminal trial, Judge.
All
I
right.
believe that's, well, family violence gave it to us since it has the new number ones.
All right. The court is calling 2023 CR 3543 State versus Moses Ross. Can I have parties announced?
Jason Gareham for the state, Your Honor.
Nick Aguilar for Moses Ross.
And are you Mr. Ross?
This one.
All right. You are here on a motion to revoke. It's a deferred adjudication, so you're entitled to a bond. Have both parties had a chance to confer on a bond amount?
Yes, Your Honor.
And have parties reached an agreement as to a bond amount?
Yes, Your Honor.
And what would that be?
On each of the cases, Your Honor, a $15,000 bond.
All right, he has two cases?
Yes, Your Honor.
All right, and what are you requesting on each case?
On each case, $15,000, Your Honor.
All right, the court is aware of the defendant's history because he's on probation out of this court. So in each cause number, the court will set his bond at $15,000. There's going to be partial GPS, each cause number. All right, thank you.
He would like to address you about the partial GPS.
I'm a full-time dad. I don't work all the time. And the reason why I'm in trouble right now is because, can I say that? I got caught with the.
So here's the thing. I don't think you want to speak to the allegations that are in the motion. So I'm telling you partial GPS for employment. Thank you. Stand by pleading true to violation of condition number 1 in 2023 CR 3543. The court could find it true, grant the motion, find you guilty, and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine.
Yes, ma'am.
Did you understand by pleading true to violation number 1 in 2024 CR 4456? The court could find it true, grant the motion, and sentence you up to 1 year in the Bexar County Jail.
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1 in each cause number?
Yes, ma'am.
And each cause number, the court will, and what have you been using?
Just marijuana.
Well, I mean, there's no just marijuana to it.
THC.
Do you want to go? Well, what I mean is, you're not allowed to use drugs while you're on probation. Do you understand?
Yes, ma'am. I when I first started probation, I had a prescription that was approved by you. That my probation officer told me it was okay.
But what is this possession about then?
It's the same, THC.
It's just THC. I get it from the stores, from like the dispensaries here in San Antonio. But and then she told me that the provider that I had doesn't get accepted by you no more. So I had to find another one. And it took me about a month, but I found it.
Well, I mean, provider not accepted by me. What do you mean?
She said,
Where he got his original prescription. It was okay the first time, and it got approved by the court. It's when it needed renewing, that same place where he got the prescription was not recognized by the court anymore.
She told me I can no longer use it.
Oh, well, then there's something wrong with that provider, because I'm just not,
Oh, I know.
Saying, oh, you're okay now, and then this time you're not okay. So,
I mean, I understand. It's just that I don't want to call it a vendor, but for the lack of a better word, the location where he'd been getting his prescriptions was no longer recognized by the court.
all right.
She told me when it expired that you no longer take that provider, and then that there's only a certain list that this court takes, and that it took me about a month to find it. And
Well, I will tell you the certain list, because people keep saying it's people that I'm not approving. There means that there's an issue with that provider.
Yes, ma'am.
It's not just me just saying, oh no, you can't use a provider, but you can use it now, but I'm going to take it away. That means that there's an issue with that provider. There's an issue with that provider's license. There's an issue with that provider's prescriptions and what they are using, the criteria they're using to give prescriptions. So as everybody stated, I really don't see the need for outpatient treatment or probation. Do you see the need for outpatient treatment? All right. So this is what needs to happen though. Whatever your prescription is, it's not a free pass for you to use more than you're supposed to be using. You understand?
yes, ma'am.
And probation, I see that it's for PTSD.
The first one was for my ACL, MCL. I have full reconstruction surgery on my knee. I fractured my lower back. I'm a barber. My back hurts. My knees kill me. Both of them are torn. And my dad was in the military, so that's documented through in the hospital.
So is it for PTSD or not?
Yes, this one is, yes, ma'am.
All right. So is there anything we need to do to address the PTSD probation? All right, then those are the court's orders.
Thank you, Judge.
You need to make sure, we're off the record, you need to make sure that you complete all these programs. And even though your probation officer is telling you, well, we can start at this time, just do it, get it out of the way, complete it. You understand? Is there anything else?
Yes, Judge, as part of his bond condition, we put him on GPS partial. I don't know if we need a separate order to remove it this morning or today.
State, do you have any objection to the removal of GPS? He's on GPS.
It's part of the bond condition that Judge gave.
No, Judge. I mean, I think one of my questions was in the new case, he was out on St. Mary's buying the product, and that was just a concern. I didn't know what time that was at. I just want to make sure he's following probation rules, as in some type of curfew of not being out late.
All right, so this is what we'll do. We'll continue with partial GPS for 30 more days. Come back and we'll see how he's doing. If there are no issues, then I'll consider removal.
Okay, can I go ahead and get that court date today then?
Sure.
Miss Boyd?
Yes.
Oh, can I get it on tracking? I'm a barber. My clients book at 9 in the morning, and I stayed here till 9 or 10. And I've been doing it for a year, 2 years.
You need to speak to the state about that. Your attorney needs to speak to the state about that. All right. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything? Yes, I'm sorry. Anything you wish to say on behalf of your client?
Yes, Your Honor. There are two issues that I'd like to discuss with the court. Ms. Vella's been sitting in jail for the last 3 weeks. And we would ask the court to take that into consideration in reference to the 10 days house arrest. If you do impose the 10 days house arrest, she is gainfully employed, and that leads to the second issue. We would ask that the court consider allowing her to go to work and home as part of the condition of a house arrest. The second issue is the fact that her employment is in Guadalupe County. And of course, we'd ask you to allow her to travel to Guadalupe County for work purposes. She works at the Tyson Food Factory, which is right off of IH-10. We'd ask you to allow her to travel to Guadalupe County while she's on probation to continue her employment there. And then the last issue we'd like to talk to the court about is the ignition interlock for half the term. Ms. Vela does not have a vehicle. She already had the handheld device, so we'd ask you to continue her with the handheld device.
All right. So, Ms. Vela, with regards to the ignition interlock, do you live by yourself or you live with other people?
I think other people.
All right, and who are these other people? Are they relatives?
My boyfriend and his mother.
Your boyfriend and his mother?
Yes, ma'am.
Do they have a vehicle?
They do.
This vehicle that you were driving, was that your vehicle?
It was mine, no.
Whose vehicle was it?
It was my boyfriend's.
Yeah. So she's going to have ignition interlock. With regards to employment.
Real quick, is that vehicle, is it running? Is it drivable?
No.
She'll have to provide proof of that.
Okay.
But I'm going to order ignition interlock. Any other vehicles at that home?
No, just it's his truck that doesn't work, and then his mom's, but I don't ever drive his mom's car.
Yeah, ignition interlock.
Judge, the mother is here if you'd like to admonish her about her using the vehicle.
No, I mean, if a vehicle is sitting in the driveway, it has to have ignition interlock on it. Now, is Child Protective Services involved?
Yes.
And the 2-year-old, where is the 2-year-old now?
With his mother, with my boyfriend's mother. She's my safety plan person.
So tell me, what were you thinking? Because I read the report, not only were you intoxicated with a 2-year-old in the car, but the 2-year-old was not even in a proper carrier. 2-year-old is just in a seat, in a seatbelt.
I wasn't, I don't know. It was a very selfish act of me, and I didn't think all the way through. I just wasn't thinking, and
so where were you drinking?
Selfish.
Where were you drinking?
I was with my sister.
At the sister's house? Or
no,
what?
I was going to my cousin's house.
So
I was with my sister hanging out, and then I just thought to go hang out with my cousin. And
The question was, were you at your sister's house? Were you at a bar, at a club?
yeah, we were just at my sister's house.
So you're at your sister's house drinking. Does she have children as well?
Not that live with her.
All right. So she doesn't have children that live with her, but she has children. Another Child Protective Services case, the reason why the children don't live with her?
I don't know what her situation is. I don't know what happened, the details of her or what happened, but I just know that the dad took him. He's in the military, and the dad took him. So
all right. And so when you were at your sister's house, was the 2-year-old with you while you all were drinking?
yes.
All right. Just wandering around while you all are drinking.
Yes.
So then after you finish drinking, then what do you do? Stumble to your car? Because in the police report, it says when they pulled you over, you almost fell out of the vehicle.
I don't think the judge is trying to make you feel ashamed. She just wants you to realize that.
Yeah. I mean, you have to realize there's so much that could have happened. You know, I had a friend, and a lot of people do not read the warning that's over the visor. And you know that warning over the visor that tells you who can sit in the front seat, and it'll tell you what their weight should be and how old they need to be. And if they're not that age and you put them in the front seat and there's an accident, the airbag will just totally sort of crush them. So my friend didn't pay attention to that, and her child was sitting in the front seat, and she wasn't driving intoxicated. And she felt so bad because her child ended up with scratches on the face. They had to take him to a surgeon to take care of the cuts to his face. But you're driving intoxicated, and you have a 2-year-old on the second passenger row that's not even in a proper car seat, just in a seatbelt. And all the people were calling because you were weaving and swerving. So how often are you drinking alcohol, and what are you drinking?
Before it got to this point, it was quite a bit, maybe every other day.
All right, so what do you know why you're drinking? What started you to drinking a lot?
Judge, if I may, on her behalf, just to help
Sure.
get her going.
Yeah.
She did commence a 12-step program. She made it through the 6th step. And I think through going through that program, I think those reasons might become clearer to her. I know one of the first steps that she learned was having to accept responsibility for behavior. When she did end up in jail, several family members were trying to get her out, and she took it upon herself to say, "Hey, look, the thing is, I got to accept responsibility. Leave me here. I'll go to court and deal with it." I don't know if she really.
So is there any mental health issues that need to be addressed? Any past trauma? And I'm not going to ask you what the past trauma is, but is that something that needs to be addressed? Is there something like that?
That is beyond my personal knowledge.
Were you raised by your parents or no?
I was.
All right.
I just, before I had realized there was an issue, I was just doing it selfishly. I don't know why. I don't know. I knew it was an issue. I had a drinking issue, but I didn't realize how much of an issue it was until all of this happened. And it took me to get to this point to realize that what I was doing wasn't right. And I have a son to raise and look after, and I wasn't putting him first. And
all right, so you only have one child? So here's the thing. I'm going to grant your application, but you're going to have to start making choices. And sometimes the choices that we make means that certain people can no longer be in your life. If your sister is not going to get her act together, she shouldn't be in your life. Because, for example, if you would have came to my home and there was a 2-year-old, I wouldn't have allowed people to just be drinking till they're intoxicated. I would have recognized certain things. And if I was not watching, you became intoxicated, I would have said, "You're not leaving, I'm taking the keys." So you're going to have to see people as they are, not as you hope they will be, because you have a 2-year-old, and that 2-year-old can't decide and say, "Hey, mom, I'm not getting in the car with you, you're intoxicated." That 2-year-old is 100% dependent upon you so that they don't have any trauma in their life, and so that they go on into adulthood. You understand? All right, this is what we're going to do. I'm going to sentence you to 2 years in the state jail facility. It will be suspended and probated for 3 years. There's a $500 fine that will be probated. Going to do the DWI intervention and education course. Ignition interlock for half the term. There's going to be a 2-year driver's license suspension. 120 hours of community service restitution. I know that Child Protective Services is probably making you do parenting classes. If they're not, you're going to do them. Once you completed parenting classes, the community service hours will be deemed satisfied.
Thank you, Judge.
Evaluation, that can be out of custody. If you miss that TAP evaluation appointment, a warrant may be issued for your arrest, because that's going to be a violation of your probation, or it may end up with you spending time at the Bexar County Jail and having them do the TAP there. You understand?
Yes, ma'am.
And I'm doing the 30 days partial GPS in lieu of the 10 days in the Bexar County Jail. And the reason why I'm doing it is because I know that the Bexar County Jail, 1, has too many inmates. 2, there are health issues there. 3, there's issues with the facilities, the actual maintenance and upkeep. All right. And with regards to the TAP evaluation, if the TAP evaluation recommends inpatient treatment, we're going to start with intensive outpatient treatment. If they recommend outpatient treatment, I still want to start with intensive outpatient treatment. And we'll do a referral to felony drug court. Felony drug court, there's no room there. There's a waiting list, but things may open up. And if they do, then felony drug court will probably accept you. All right. Probation, is there anything else she needs?
Your Honor, you mentioned proof of employment.
Thank you. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Anything else, probation?
No, Judge.
Is there anything else you need from the court?
Judge, just the permission to travel to Guadalupe County for employment.
All right, she's allowed to travel to Guadalupe County for employment. All right, is there anything else you need from the court? You need to say yes or no. All right, I'm showing you what's entitled trial court certification of, you probably need to come around. I'm showing you what's entitled trial court certification for defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Yes. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Thank you, Judge.
You're welcome.
Judge,
Good morning, how are you doing?
I'm doing good. For once, I'm not hot. For once, I'm like, usually I'm sweating up a storm.
So you all ready to proceed?
Yes, Judge.
All right, everyone, we're on the record. Court is calling 2023 CR 8486, State of Texas versus Annabelle Vela. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
For the defense.
Paul Acevedo for the defense.
And are you Miss Vela?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Annabelle Marie Vela who was placed on community supervision in 2023 CR 8486 for the offense of driving while intoxicated with a child under 15 on October 23rd, on October 30th, 2023 for a term of 3 years? Is that you?
Yes, ma'am.
State?
Violated condition number 12 on or about the third day of June 2024 in Atascosa County, Texas. The defendant, Annabelle Marie Vela, operated a vehicle without a valid Texas driver's license in violation of condition number 12.
How do you plead to that? True or not true?
True. Driver's statement is all the violations.
Any objections?
We have no objections, Your Honor.
Did you understand by pleading true to violation of condition number 12, the court could find it true, grant the motion, and sentence you to 2 years in the state jail facility?
Yes, ma'am.
And a $500 fine? All right, we're on the record. Don't approach the clerk while we're on the record. All right, don't approach while we're on the record. All right. Knowing that, do you still wish to plead true to violation of condition number 12? Court will find violation of condition number 12 true. Is there a proposed agreement?
Yes, Your Honor. It's the alternate amend for the defendant to take a defensive driving course and to continue on probation. Sorry.
All right. Why is she driving without a license?
Would you like for me to address it, or would you like to hear it straight from her?
Sure. Could you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Annabelle Vela.
Judge, she is a little nervous, so just
Oh.
just a little patient.
Yeah, don't be nervous. Just tell me the truth. Why are you driving without a license?
So I was with my friends. I know I wasn't supposed to be driving. She told me she wasn't feeling well. A couple years ago, she had fractured her spine and her tailbone, and it often causes her to have back problems where she can't walk or sit too long. So she asked me, like, hey, like, we're a couple minutes away, a couple miles away. Can you just finish out the drive, get us there, and then my boyfriend will drive us back, and then I can Uber you home from there. So I was like, I'm really not supposed to, but you know, you're not feeling well and we can't just sit on the side of the road. So I'll just finish out the drive and then that's it.
Did somebody have a phone to call the boyfriend?
She did, but he was at work and he was about to be off. So I don't know what, I didn't think of it at the time. So I just agreed. I was like, okay, I'll get us there. But then after that, I can't do no more because, you know, I can't be driving and she's aware that I can't be driving, but I'll help you out and I'll just get us there and that's it. And it was not far. I hadn't been driving long before the cop pulled us over.
Well, see, the issue about it's not far is neither here nor there. You're not supposed to be driving, period.
Yes, ma'am.
And then you're driving and you don't have a license. And then you're driving and you're not insured. So if there were an accident and you're driving without a license and you hit somebody, do you think anybody would care that, oh, it was just 2 blocks away?
No, ma'am.
Judge, if I may, on her behalf, I don't think she gave the full story, the way it really worked out. This friend that she's talking about is not just a friend, it's somebody that she's met recently and she's met her through her employment. This friend is her supervisor. She was still on the clock at work and the supervisor was off the clock at this point. The supervisor returned to work to give her a ride home and that's when this transpired. When she was actually getting ready to give her a ride home and then she felt ill. I had an opportunity to run her name through DPS. She is eligible for her driver's license. And we've talked about making arrangements to get her driver's license back. No occupational license is needed at this point. It's just a matter of getting caught up on some fees and DPS fees at that, Your Honor, and paying the endorsement for the driver's license. She did self-report this. It was filed as a Class C misdemeanor because it's a driving while license invalid as opposed to driving while license suspended. And she called me. I told her bring it in. I'll help her take care of it. She reported to probation a day or two later, and she self-reported it to probation at that point. She herself is up to date on all of the conditions with probation. She's has taken some steps in life because of this probation that has made her a little bit more responsible. Not a little bit, a lot more responsible. Financially, she's making better decisions. On a personal level, she's making better decisions. And on the course here, she's trying to make some better decisions. I asked her what has happened, and, you know, what's causing you to do these things. And she said, to be honest, the judge spoke to me the last time and she talked to me about accountability, and I'm, you know, trying to be accountable. Thus the self-reporting and so forth. I don't want to speak out of line, Judge, but I do believe if she would have never said anything, chances are the ticket Class C would have been taken care of and nothing would have ever happened. And of course, she did self-report and let the probation department know that she did receive the ticket.
And State, what are you requesting?
I was again listed.
And probation, what are you requesting?
Defensive driving, Judge.
All right, the court will deny the motion. Alternate amend conditions to include defensive driving. You're not supposed to drive without a license, period. I understand now that your attorney, we can go off the record, your attorney explained that the person with you was your supervisor. So I can understand feeling pressure because it's your supervisor and you could end up getting fired. But you are not allowed to violate conditions of probation. You're not allowed to drive without a license. You understand? All right, good luck to you.
Judge, can I just address one more issue that I feel like we need to address, and just to have a clear understanding. She does not own a vehicle right now.
Mm-hmm.
She is using the handheld device. She has the Scram device.
Mm-hmm.
So she hasn't had any violations and so forth. However, when she does apply for a driver's license,
Mm-hmm.
she has to pay for a ignition interlock endorsement, but she doesn't have a vehicle. So she will have a license that says ignition interlock, but if she is driving again, she's gonna have a scram device. I don't know how technically how that would work with DPS.
I don't know. What would end up happening is if she has a driver's license and she has her vehicle, just come back and we'll address it.
Okay, thank you, Judge.
Oh.
Yes. Thank you for dressing appropriately for court.
Oh, Acevedo.
You're charged with criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have, all right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We are. We asked you follow the agreement, Your Honor.
All right. How old are you?
JudgeBoyd, I'm 53.
Why are you throwing rocks at somebody's vehicle, like Ernest T. Bass? Why are you doing that?
Disrespectful to my mom. I know I shouldn't be doing it, but you know, it's
Wait a minute. Was this your mother's vehicle?
no.
All right. So what about the disrespect to the complainant? Why are you?
I know.
Yes. Why is he throwing rocks?
So, unfortunately, the complainant is the defendant in the case against his mother.
They're neighbors, Your Honor.
They're neighbors, and unfortunately, it's just a complicated neighbor situation.
I mean, it's calmed down now.
Right. He understands
And
that
I
there
don't-
should be no contact and no communications. And he's committed to being successful in that.
Well, this is not Mr. Rogers' neighborhood, is it?
No. No. I'd like to go there, though, if that's an option. I'll move.
All right. Is this the only offense he's ever had?
No.
What's the previous?
He does have prior history. It's not, I don't want to misrepresent anything. I do think there has been a less than a gram use in the past and some other misdemeanors. And then, yeah, obviously the case was arrested.
And where did you find rocks?
In my yard.
Okay. All right. Court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There's a $500 fine that will be probated. Proof of employment within 30 days. No employment as a home health care provider or with minors. Are you currently employed?
No.
How do you support yourself?
I get this disability check, but mom mostly helps me out.
He lives with his
Yeah.
80-something-year-old mother
Yeah.
and helps care for her.
And what's the nature of your disability?
I'm looking to find a job. This is my back. I have minor back problems, but I'm looking to find something to get back to employment.
All right, so I require people work when they're here. Unless you're 100% disabled, you're going to need to find employment. You understand?
Right.
So proof of employment within 30 days, no employment as a home health care provider or with minors, regular reporting by Zoom or in person, regular random UAs. There's to be 100 hours of community service restitution. I'm going to order the MRT. Once he completes that, community service hours will be deemed satisfied. Field visits 1 time per month for 6 months. There's to be no contact with the complainant. And Ms. Ferguson, can I have a restitution hearing in 30 days, please? Is that enough time for the state?
It should be, Your Honor.
So there's going to be a restitution hearing on September 18th. There is to be taken in consideration 2025 CC 011039. Probation, anything else? All right, is there anything else you need from the court to be successful?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yeah. Yeah.
Because this is plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. With regards to his warrant, is that related to this case?
No, Your Honor, the warrant is related to the case that's being TIC'd. I don't know if the court would sign the dismissal or I need to.
No, you'll have to go to county court number 9, and then county court 9, they'll be in charge of the warrant.
Okay, well, y'all take it down to 9 then after this?
All right. All right, good luck to you.
Okay, I'll follow up.
You
with
better.
JudgeBoyd,
All right,
thank
you're
you.
welcome.
Will I have to, will I be released?
You'll have to take it up with county court
I'm
at
gonna
law
work
number
on it.
9.
I'm gonna get the dismissal side of it. So,
Did I do it?
All right.
you're gonna go with that, and I'll talk to you later, okay?
Will they release me?
Hopefully. in the next
All right, and
while.
counsel, on your other case?
The Lauren are here to talk about.
It's so funny. When we were in law school, they never asked you to say, what should I say when my client is not here? But I love you should acknowledge the question. I love where you acknowledge it. Great question.
Well, I believe in starting positive. So, I have been in communication with my client. He is not able to Zoom in today or appear in person. So, the state has done a great job. They do have 2 witnesses here for the rest. This is just a restitution issue. So I would either ask that the court proceed with the hearing without my client, which I don't know if I can really do that, but I'm throwing that out there. I would ask, or if not, the court reset the date and not issue any sort of warrant.
I mean,
and hopefully he would appear in the future by Zoom or in person.
Yeah, he's not here, and we're scheduled for a hearing, and the state has witnesses. Deputies, could you make an announcement in the hallway for Christopher Patrick Consolato? That sounds like, the names from soap opera Santa Barbara.
I would say that's a fitting description.
Yeah. I'm telling you. I don't know why Odyssey keeps kicking me out.
That means he's not meant to have a warrant. Absolutely. The flowers are beautiful.
Oh, thank you. All right. So what I can tell you, what I will do is I will issue a judge's warrant. And if you have him in here tomorrow, the court will reconsider. But state has their witnesses here. So my suggestion would be you all confer on what the amount will be. And if the state witnesses are not available to appear tomorrow, then I'm going to allow them to appear by Zoom.
And if Lauren and I are able to reach an agreed restitution amount this morning, if the court accept that and not issue a warrant?
Well, if your client sort of has to be here to agree to it.
Okay.
But if you all, I will tell you this, you communicated with him, and if he appears by Zoom or in person and he accepts that.
Okay. I'm going to discuss that. I'll talk to Lauren, see what we can.
And when I say if he accepts that, I'm not asking that he accept the amount in exchange for he doesn't have a warrant. The judge's warrant will be issued, but the court will strongly consider recalling the warrant if he appears tomorrow in person or by Zoom.
Wonderful.
And it has absolutely nothing for you to do with any agreement that you all may or may not reach.
That sounds perfect.
All right, thank you.